Hello friends, very warm welcome to my business laws channel. Today friends, I am going to take up frequently asked questions from the Sale of Goods Act 1930 and how to answer them. Business law is the paper which many students study in CA, BBA, BCom Honors, BCom, LLB, MCom, BBA and MBA also. So friends, I have already covered in my last video, frequently asked questions from the Indian Contract Act 1872. So today I'll take up the Sale of Goods Act 1930. So let us start now. There are 5 chapters which are there in the unit of Sale of Goods Act. The very first chapter before you is the nature and formation of contract of sale. In this chapter, friends, I have taught you in my video, meaning of contract of sale, then difference between contract of sale and agreement to sell. And apart from this, number of headings have covered. What is the meaning of the term goods, subject matter of contract of sale, and then what is included in the subject matter of contract of sale, what is excluded from the subject matter of contract of sale, which are the various methods of ascertainment of price, and what is the effect of perishing of specific goods. So the questions which have been asked from this chapter in the examinations are, friends, distinguish between sale and agreement to sell. There are 8 to 9 points of distinction. Already, friends, in my videos, I have told you distinctions should be written in the T form, tabular form. So 4 columns, serial number, basis, first term, and then the second term. So 9 points of distinction are there. So main is the title, transfer of ownership, which takes place in case of sale immediately, but it takes place as a future date or when some conditions are satisfied in case of an agreement to sell. So sale and agreement to sell, then of course other points are also there. Who will bear the risk if buyer commits default? What option is available to the seller? Similarly, if seller commits default, what option is available to the buyer? So insolvency of seller, insolvency of buyer, 8 to 9 points are there. These which types of goods are dealt with in both the cases. Are they specific goods or future or unascertained goods? So friends, in my videos I have covered all these. So you have to write all these 9 points in the T form under the heading distinction between sale and an agreement to sell. Another question which has been asked in the examination from this chapter from this act is, define the term contract of sale and what are the essential features of contract of sale. 6 to 7 points are there. 2 parties, transfer of ownership, delivery of possession. Okay, then movable goods. Contract of sale is only concerned with the movable goods. And then movable goods have been defined under section 2, subsection 7. Okay, and then price. The contract of sale, in case of contract of sale, transfer of ownership always takes place for a price. So price is the main consideration. Partially, the payment may be made in cash or in kind, but the entire payment cannot be made by way of money, by way of goods. Partial total payment in terms of money, or partial in terms of money and partial in terms of goods. But if the goods are exchanged against goods, then that is known as barter system. So what is the meaning of contract of sale? It has been defined under section 4, subsection 1. Contract of sale is a contract whereby seller transfers the property and goods to the buyer for a price. He transfers or agrees to transfer the property and goods to the buyer for a price. So 6 to 7 essentials of contract of sale are there, which you have to write with the help of examples. Another question which is asked from this chapter is, define the term goods. Then explain the classification of goods. The term goods has been defined under section 2, subsection 7. Goods means all movable goods, or future goods. Goods can be classified under 3 categories: existing goods, which may be ascertained, specific, or unascertained, or future goods. Then we can have future goods and then contingent goods. So friends, 3-way classification: existing goods, future goods, contingent goods. Now, future goods are not owned and possessed by the seller at the time of formation of contract. They are to be acquired, or they are to be grown in the future period. And after they are grown, they are to be sold by the seller to the buyer. So, term goods, subject matter of contract of sale is the goods. Goods includes all movable goods, or those goods which are grown and which are to be separated from the land. That will also fall under the category of goods. But goods does not include actionable claim and money. Money is a legal tender money. Okay, and then actionable claims are those claims which can be enforced through legal action only. Based on the judgment of the various case laws, by the judges, subject matter of contract of sale includes, there are a number of inclusions: all movable goods, tangible goods, copyrights, patents, cables, decree of the court. So all these are included under the term subject matter of contract of sale. But subject matter of contract of sale excludes immovable property, lottery, services, actionable claims, and money. Then friends, you have to explain all these: existing goods, specific goods, unascertained goods, future goods, contingent goods, with the help of examples. Remember, regarding future and contingent goods, we can only have an agreement to sell. We cannot have sale transaction. Because goods which are not here in the possession of seller, how can the ownership of those be transferred? And apart from this, sometimes the question is asked, explain the various modes of ascertainment of price. 5 to 6 modes I've covered in my video, which are given under section 9 and 10. All those 5-6 points you have to write in the answer for this question. Another is, what is the effect of perishing of specific goods? If specific goods perish before or at the time of making of contract, as per section 7, then the agreement becomes void. But if they perish after an agreement to sell, but before sale, then the valid contract is transformed into void as per section 8. So the the principle of subsequent impossibility will apply. And the principle of restitution will also apply. So this is all about the various questions from the first chapter under the Sale of Goods Act 1930. Now moving ahead, the next chapter is conditions and warranties. Very important chapter from examination point of view. Distinguish between condition and warranty. How can the breach of condition be taken as a breach of warranty? 3 to 4 points of distinction are there, which friends you have to write in the tabular form. The term condition has been defined under section 12, subsection 2. Warranty has been defined under section 12, subsection 3. There is a difference between the two. Stipulation is different in both the cases. Significance of stipulation. Then breach of each one gives different right to the buyer. Right to put an end to the contract in case of condition, but right to recover damages in case of warranty. Breach of condition can be taken as a breach of warranty, but breach of warranty can never be taken as a breach of condition. If the buyer has superior right, but he doesn't want to exercise superior right, he wants to exercise inferior right, he can. But if the buyer has inferior right only, then he cannot exercise superior right. How can the breach of condition be taken as a breach of warranty? There are 2 points regarding this. which you have to cover in your answer. First is the voluntary waiver. On voluntary basis, he wants to waive his right of rescission of contract. He wants to treat the breach of condition as a breach of warranty. And second is compulsory treatment of breach of condition as a breach of warranty or acceptance of goods by the buyer. In the second case, where the goods is of goods where the contract is entire or non-divisible and part of the goods have been accepted by the buyer, and regarding remaining part, he cannot exercise breach of a condition as a breach of condition. He is bound to exercise the breach of condition as a breach of warranty. Say he ordered 10 Acer computers. They are not Acer. Different brand has been supplied by the seller to the buyer. Out of 10, he has accepted 5, and the contract is entire, we are presuming. Then remaining 5 also he will have to accept. And then he can claim damages. So breach of condition will be taken as a breach of warranty. And then the rule of Cavitamiter. Explain the rule of Cavitamiter and state the exceptions to this rule. This also is the important question which has been asked in the examination from this chapter. Let the buyer beware. Caveat-emptor is made up of 2 words, caveat and emptor. Caution and then conscious or caution, and then emptor is buyer. Let the buyer beware. As per section 16, buyer must be very careful, but there are certain exceptional cases where this rule is not applicable. That is, buyer can hold the seller responsible for the loss. Then which are the implied conditions in the contract of sale? 7 conditions. Title, description, sample and description, quality or fitness, merchantability, and then last is as to wholesomeness. All conditions, implied conditions have been laid down under section 14 to 17 of Sale of Goods Act. So friends, you will have to write along with the examples or case laws. Because in long questions, case laws or examples, you must write to create good impression upon the paper evaluator. So these 3 questions have been asked from this chapter. Moving ahead, third chapter is transfer of title or ownership or property in goods. Explain the various provisions pertaining to the transfer of ownership or title in case of specific or ascertained goods. This is often, frequently asked question from this chapter. And another question which is asked is nemo dat quod non habet. Non-owners cannot make a valid sale. A seller cannot convey better title than what he himself possesses. So section 27 provides non-owners can make valid sale in certain exceptional cases. So I would like to give the answer for the first question. Provisions relating to the transfer of ownership where the goods are specific or ascertained one. The points have been provided under sections 21, 22, 20 and then 24. Where the goods are in the deliverable state, where the goods have to be put in the deliverable state, where the goods are to be weighted in order to ascertain the price, or they are to be measured, or where the goods are sold on sale or approval basis as per section 24. So friends, you will have to explain all these 4 points with the help of examples or case laws. The nemo dat quod non habet, non-owners cannot make a valid sale. Exceptional cases, there are 8 points. Sale by estoppel, sale by a person in possession of goods under wardable contract, sale by a co-owner, then sale by a buyer in possession of goods after an agreement to sell, sale by a seller in possession of goods, before sale, and then sale by unpaid seller, sale by pledgee, sale by finder of goods, sale under the Negotiable Instrument Act, sale by official receiver or assignee. So friends, 8 points are there, 8 exceptional cases where non-owners can also make a valid sale. All these points you will have to write with the help of theory as well as case laws or examples. Priest versus last is the very important case law. It was the case law regarding implied condition as to quality or fitness, which you have to write there. So under this transfer of title, all possible questions I have given you, you can write the answer for these questions. Performance of contract of sale is the second last chapter under the Sale of Goods Act. In this chapter, the question is asked, explain the various rules pertaining to the delivery of goods. So 12 rules have been given under sections 31 to 40 of the Sale of Goods Act. When should the goods be delivered? At what time the goods should be delivered? The seller should deliver the goods first or buyer should pay the price first. Then what is the impact of part delivery of goods? Who has to bear the expenses of delivery of goods? 12 points. Well, what will happen when the goods are in the possession of third party? Buyer has a right to examine the goods. If the goods are sent by ship, then and the goods get damaged on the way, who will bear the loss of destruction of goods? So 12 points are there, friends. First of all, you will have to define the meaning of delivery of goods. Delivery of goods term has been defined under section 2, subsection 2 of the Sale of Goods Act, which provides delivery of goods is the voluntary transfer of goods by one person to another. Remember, it is voluntary. If goods are obtained at gunpoint, pistol point, that will not amount to delivery of goods. So all 12 points you will have to write in the question when you write the answer for this question along with the examples. Last chapter is Unpaid Seller and His Rights. Very important chapter. Unpaid Seller and His Rights. Now 2-3 questions are asked from this chapter. They have been asked in the EU examinations and other examinations. Who is an unpaid seller? Explain his rights against the goods. Unpaid seller has been defined under section 45, subsection 1. Unpaid seller is a seller who has not been paid whole or part of the price, or who has been given bill of exchange or any other negotiable instrument which has been subsequently dishonored. What are the rights against the goods? 2 cases: when the ownership has passed, when the ownership has not passed. When the ownership has passed, 3 rights: right of lien, right of stoppage of goods in transit, and right of resale. And when the ownership has not passed, then right to withhold the delivery of goods. Now, distinguish between right of lien and right of stoppage of goods in transit. 5 to 6 points are there. You have to write this distinction in the tabular form. Okay, so these 2 are the important questions which have been asked from this chapter in DU examinations and other examinations. All points: right of lien as per section 47 to 49, right of stoppage of goods in transit 50 to 51, and right of resale as per section 54. All these you will have to write along with the examples or case laws, which will create a very good impression upon the evaluator. So friends, in my today's video, I have covered all questions which have been asked in DU examinations and other examinations. I hope you must have understood. If you have any question, or how to answer that question, you can always write in the comment section. So it is all from my side regarding this. Thank you all for viewing this, and I hope you will like this video and do press on the bell icon to get notifications of my subsequent videos. Keep smiling and stay blessed always. We'll meet soon. Goodbye.